Thank you
for nurturing smart teachers and having known that you are a renowned, experienced faculty in public international law. We'll be talking about law and practice of treaties. Now, my first question is, how old is the law relating to treaties?
So firstly, I would like to thank you today that you are organizing this very important series of lectures and interactive programs on different aspects of international law and many other topics of interest for many students and many practitioners of India as well as all over the world. Now coming to the question that you have asked, that how old is the law of treaties? Actually, formally, the law of treaties has been evolving since the last 50 or 55 years, but treaties have been there for a very long time. So there has been a lot of practice. If you have the example of India, we can have the very old practice of conclusion of treaties between Alexander the Great and the Porus. So this was a great fight and imaginative one. Even people today, they understand
history way back.
Yes, that yes. What kind of treaty that might have been. So there also it is said that Alexander and Porus, they had concluded a treaty, and then some of the portions were given to the Indian king, and other portions were taken by Alexander. And after that also, one of the ambassador of Alexander, Seleucus,
yes,
he fought with Chandragupta Maurya, and he even offered his one of the very good bride for Chandragupta yes. Maurya. So
quite right.
Yes,
now,
but the modern law of treaties, that has been evolving since the last 50 years. When a very particular convention that was agreed upon, and that is called Vienna Convention on the law of treaties.
Now, this law of treaties, as we see today, what is its aim and purpose? Why should this be taught? What is the need?
So in the last 75 years, the whole world is moving in a different way. It's much more organized, it's much more modern, and the relationship amongst the countries, those have to be regulated on a more formal basis. So in this backdrop, we can say that how the United Nations was created. And if you look at the United Nations, it is an institution, but then it is working on the basis of a treaty. So the Charter of the United Nations. Now how this charter, what is the importance of the word charter? And then if you look at the Statute of International Court of Justice, now that International Court of Justice is simply an institution, but then it works on the basis of law, and that is contained in the treaty, which is called as the Statute of International Court of Justice. So if ICJ today has to decide some case, then it will take into consideration the statute of ICJ.
Now that brings me to the question, since you have said that it is only 50 years or so that law and practice of treaties has been in existence. Now, what comes to my mind is that what is its benefit? How are we better than the times when there was no law of treaties?
Very good. Because,
can you explain this?
Yes, because for the first time when the Vienna Convention on the Law of Treaties, that was concluded way back in 1969. So at that moment of time, Article 2, first paragraph and clause A, that was very specifically writing down that what is the meaning of treaty. It says that treaty is an agreement which is in written form, and by which the nations who conclude the treaties, they would become bound by international law. So it means that now if the countries are going for a treaty, it means that they will observe it. And why is it so? Because there has been a very long, very age-old earlier it was an adage, but now it is also law, and that is called pacta sunt servanda. It means that pacts must be served in good faith.
Okay.
So now the importance of treaty is that if a country is going for a treaty with some other country, and then what will happen, that the countries would become bound by it. So if a dispute will arise in future, so the dispute can be resolved on the basis of the said treaty,
Within the four corners of the treaty.
Okay. And not only that, states, but nowadays what is happening, that even there are so many international organizations. So after the Second World War, United Nations is the foremost example of international institution. After that, there are a lot of international institutions like ICJ, like International Criminal Court, like WHO. Now, these are all working on the basis of some treaties which have been signed.
Okay. Now, as you are aware that the primary purpose of this project, Nurturing Smart Teachers, is to enable the young lot of teachers who are coming, that they should be spoken to, they should be lectured, and presentation given by an eminent professor. Now, a question that comes to my mind is that how is teaching of this subject different than teaching of, say, law of contract or tort or Hindu law or anything? Is this a special branch of law that needs a separate teaching, or anybody can teach this?
No, this needs a separate branch. So there are two ways in which this course is being taught. The first is that this is a part of compulsory course. So when a student of law who enters into LLB program, so say if this is a semester program, then in the second semester it is a compulsory course of public international law.
Okay.
Now within public international law, you have to understand what are the sources of international law. So when we come to sources, then the very important source nowadays is treaties.
Okay.
So generally students, because when I take classes in Delhi University, I come to know that many students, they do not understand what can be the difference between, say for example, an agreement, say for example, a statute of International Court of Justice, say for example, what is the meaning of convention. And even if suppose if they have a little bit of idea, then they will not understand that how is it important for the future of a country in dispute resolution, in abiding by the obligations which have been taken by a country. So this will be also looked at by the students of first year. And if they have understood this one in the first year, then in the second year some elective courses are there. So for example, if they will take up human rights, so they will have to take again some treaties. So there will be like International Convention on Civil and Political Rights, International Convention on Economic, Social and Cultural Rights, and then only they will come to know about Human Rights Council and all. So
therefore, a basic knowledge about the law of treaty becomes significant.
Essential.
Yes.
And particularly because this is a compulsory course.
Okay.
And after that, if the students have little bit of more interest, then they can choose some elective papers, and there also they will have, they will have to understand. Because I remember that when I was teaching international economic and trade law, and I asked one of the students that, okay, tell me that what is the difference between a resolution or understanding between two countries and a treaty, suppose general agreement on trade and tariff. So what is the difference? Then, and the student was an advanced student of LLM. So the student could not answer properly. So the thing is that, in LLM level also people choose the subject of, suppose even if international trade law they take, they will have to understand that what is the importance of GATT, which is General Agreement on Tariff and Trade, and how is it different from other soft laws. So treaty is a hard law, but other resolutions or other statements, joint statements, they can be soft laws. So they will try to understand all these things and what are the differences, etc.
I see your point. Now, what would be your advice to young teachers who are assigned to teach this particular course? what books or literature should they use mandatorily to teach this?
Yes, so because the students, if suppose if they are coming in the first year, so they should not be told about the nitty gritties of the whole nuances of treaty interpretation or revision of treaty or invalidity of treaty. But then the basic elements of treaty, suppose treaty making, what is the meaning of signing of a treaty? What is the meaning of ratification of a treaty? What is the difference between signature and ratification if ratification is required? Then what happens if a country becomes a member,
Okay.
signatory member or a member who has ratified the treaty? So these things have to be taught, and therefore the basic books on international law. For example, I generally refer to cases and materials.
Cases and material on international
Yes,
law.
so that is written by DJ Harris.
Okay.
Now it has been also, the latest edition has been edited by not only DJ Harris but also by Shiv Kumaran.
Okay.
So Harris and Shiv Kumaran book on cases and materials on international law. So this is a basic book. But apart from that, there are some specialized books on treaties. For example, Anthony Ost.
Okay.
So Anthony Ost has written a book, and that is going, currently it is running in the third edition, and that has been published by Cambridge University Press. So third edition is the latest one. So
These
teachers
books
can
come to the mind.
Yes, Fitzmaurice book is also there. In India, we have the book which is very old, but then that is even today it is considered as very
Standard
authoritative.
Yes.
So S.K. Agarwala, he had written a book. It was an edited book, in fact. So in way back in 1973, when the whole discussions that how this Vienna Convention on the Law of Treaties that would be implemented, because I told you VCLT, Vienna Convention on the Law of Treaties, that was concluded in 1969. So
Immediately after that,
just
in
after that,
73,
so he had convened a conference in Pune. He was there in Pune.
Yes.
So he had convened a national conference, and many people from all over India, scholars as well as ministry officials, they had gone there.
Yes.
And they gave their papers, and finally it was published in.
Okay.
So-
So thanks. This brings me to the end of part 1, and we would then move to part 2 of the presentation. Thank you. Just take 3 seconds.